Welcome back to the deep dive. Our mission today is, it's pretty ambitious. We're going to travel across continents and, well, centuries to uncover what is, frankly, one of the most foundational ethical principles for any society.
And it's one of those non-negotiable ones, really.
Absolutely. The idea that private property rights, they form a sacred and uncrossable line against the power of the state. We're really cutting straight to the core tension here between, what the state needs and what the individual has a right to, their dignity.
Right.
And our sources for this, they bridge this just staggering gap. I mean, we're putting texts into conversation that are separated by 1,400 years and thousands of miles.
It's an incredible comparison to make.
Our timeline starts with the 7th century prophetic charter of Medina. Many scholars, they consider this humanity's first written constitution for a multi-group society. Then we fast forward all the way to the 21st century.
Straight into the modern legal battles.
Exactly. To the tumultuous constitutional debates around something called eminent domain, right in the Supreme Courts of the USA and Pakistan.
And what's so fascinating here, I think, is realizing that the moment you have organized governance, whether it's this nascent state in Medina or, the founding of the American Republic, the people framing these systems, they immediately get it.
Get what specifically?
That the security of life and the security of property are, well, they're inseparable. If the state can just arbitrarily strip you of your assets, your home, your land,
your liberty just crumbles.
It inevitably crumbles. So we're looking at three profoundly distinct traditions. You've got early prophetic law, American common law, and South Asian constitutional law. All of them arriving at the exact same moral conclusion, but through completely different paths.
And at the heart of this whole deep dive, there's a question. It seems simple on the surface, but it's absolutely vital for you, for any citizen.
Right.
What happens when a government decides it needs your private property for what it calls the greater good, or public welfare?
That's the phrase they always use.
It always is. So when does your home, your land, your livelihood, when does it stop being just a negotiable asset and start being an ethical boundary? One that's protected not just from, say, a thief, but from the government itself. That's the line we're tracing today.
Okay, so to really start our journey, we have to set the scene. We're in the year 622 CE. This is a moment of just profound transformation.
This is the Hijra, the migration.
Exactly.
Right.
The Prophet Muhammad has migrated to Yathrib, which is, soon to be renamed Medina. And the society there is, well, it's fractured, highly fractured. You have two major Arab tribes that have been locked in conflict for generations.
A cycle of vendettas, basically.
Absolutely. Then you have various Jewish groups who held significant economic power, and then the newly arrived Muslim migrants from Makkah. So governance was, to put it mildly, chaotic. It all relied on kinship, blood ties, and frankly, brute force.
So in that kind of environment, I have to imagine property rights weren't exactly secure.
They were extremely precarious. That's the perfect word for it. If a strong tribe or a powerful individual wanted assets from a weaker group, they often just took them. An act known in the Islamic legal tradition as gasp.
Gasp. What does that translate to, roughly?
It means something like unjust seizure or dispossession. It wasn't just theft. This practice, this arbitrary taking, sometimes they'd call it a tribute or a tax to make it sound official.
Yeah.
It was the default setting for how tribes dealt with each other.
So the Charter of Medina, it wasn't just about theology or creating a military alliance then. It sounds like it was a social contract, something designed to bring order from absolute chaos.
That's precisely it. It was a revolutionary document both administratively and ethically. This charter, which many do consider the first comprehensive written constitution, was designed to forge a single community in Ummah out of all these different groups.
And its real significance then is that it replaced the rule of force.
With codified law and guaranteed rights for every group that signed on, regardless of their religion or tribe. It created a political entity that was based on shared legal responsibility, not just shared bloodlines.
And it's right there, inside this foundational text, that we find this ethical breakthrough about property. This is where governance moves beyond just regulating things and into setting a moral mandate.
Yes. The profound implication is in the specific provisions. The protections were extended to all the communities, Muslims, Jews, everyone, treating them as equal parties under the protection of this new state structure.
So it wasn't just protection for the ruling group, it was universal. It was universal within the system. And the document states it explicitly. In clauses 21 and 38, among others, you find this decree. It says, "The property of every group shall be respected. It shall not be taken unjustly." Shall not be taken unjustly. Let's unpack that phrase. You mentioned the term gasp.
Yes, unjustly is the translation of gasp, and it's a critical legal term. Gaspy isn't just simple theft, one person stealing from another. Gas implies a forceful, unauthorized, and fundamentally unjust seizure, often by someone in a position of power.
Like an official.
Exactly, an official, a tribal chief. So this one clause immediately puts an absolute ethical boundary on the authority of the state or the collective tribe. It's a direct rejection of that might makes right philosophy that had governed Arabia for centuries.
It established that private ownership was sacred, in a way, and protected, and that the state itself had to step in and provide restitution if someone's property was wrongly taken.
It was transformative, because it meant the weakest property owner was now protected from the strongest tribal leader. It asserted that law, not lineage or power, was what dictated who owned what.
And this leads us to these core legal principles he established. The prophet wasn't just, writing a rule against theft. He was creating a system of administrative law and state accountability. And for the 7th century, that's astonishingly progressive. He was. And that's the crucial step forward. Establishing state liability for officials who abuse their power. If an official, say a governor or a tax collector, acting under the color of authority, wrongly seized property, the state was required to make immediate and complete restitution. So it wasn't enough to just punish the official later on. The citizen's right had to be restored right away.
Immediately. This principle of state accountability is a cornerstone of modern constitutionalism, and yet you see it being established in Medina 1,400 years ago.
I have to ask, though, the system of government was highly centralized under the prophet's authority, right? So how did this immediate accountability actually work in practice? It's not like there was a complex bureaucracy or court system to filter it through.
That's an excellent point. It was centralized, yes, but the accountability was direct and it was moral. And the sources give us this incredible illustrative case, a story that moves the principle from abstract law into high drama. It shows us how the system worked when it was really tested.
Okay, so what happened?
A man approaches the prophet. He's complaining about a specific governor, one of his appointed officials, who had seized his land. Now, the context strongly implies this wasn't for the governor's personal gain. It was for some kind of public use.
Like what?
Maybe land needed for a public market, or barracks for soldiers, or even housing for the new migrants. The point is, it wasn't a common crime. It was an act by the government for what it probably saw as necessary development.
Okay, so if this happened today, the citizen would file a lawsuit, it would drag on for years, maybe they'd get some compensation at the end. What was the response in Medina?
The response was immediate. It was angry, and it was categorical. The sources describe the prophet's reaction as one of profound moral outrage. He didn't ask for a commission to study the land use. He didn't suggest a compromise. He issued an immediate, non-negotiable decree.
Which was?
Return the land to its owner immediately.
Wow.
And his anger, it wasn't aimed at the project's necessity. It was aimed at the manner of the acquisition, the injustice of taking it without the owner's consent or proper compensation.
But the most powerful part of the story is what comes next. He didn't just stop at the earthly correction. He invoked an ultimate spiritual consequence. This is where the law becomes ethical and religious doctrine. It provides a level of deterrence that no civil fine could ever match. He declared, and this is a famous tradition, whoever takes land unjustly, even a handspan of land, will be sunk into the earth on the day of judgment. Quote, so he elevated property rights from just a civic matter to a matter of eternal salvation or damnation. Exactly. For an official who might be thinking about the easy route of illegal seizure, the consequence wasn't losing your job. It was ultimate eternal punishment. This set the foundational principle. The state cannot take private property unless it meets the absolute highest ethical bar. Justice, undeniable necessity, and implicitly consent through fair compensation and due process. The state is subservient to these limits. That is a powerful concept to carry forward. The idea that the right to property is so fundamental that violating it has a spiritual penalty. It ensures the ethical standard is always higher than the political convenience of the moment. So let's now jump forward 1,400 years and see how this ethical boundary holds up when it's confronted with the needs of a modern industrial state.
A very different world.
Completely. We now arrive in modern America, where this same philosophical battle over property rights is waged under the framework of the U.S. Constitution and the concept of eminent domain. So eminent domain is the inherent power of the government to take private property. In the U.S., this power is regulated by the Fifth Amendment specifically the Takings Clause, which says that private property shall not be taken for public use without just compensation.
Mm.
And the entire tension point, the constitutional fault line, it lies in how you define those two words, public use.
Right. What does public use actually mean?
Well, traditionally, it was interpreted very narrowly. Property had to be physically used by the public, a road, a military base, a post office, a school, things like that.
Things everyone could literally use.
Exactly. But as the American state grew, governments started to stretch that definition, especially during the mid-20th century for things like urban renewal and clearing blighted areas. But the 2005 case of Kilo v. City of New London, that stretched it to a point many people saw as breaking the constitutional spirit completely. Let's get into the specifics of the Kilo dispute, because the facts here are so important. This wasn't about building a fire station or a hospital.
Not at all.
Suzette Kilo was one of 9 homeowners in a modest neighborhood in New London, Connecticut. Their homes were targeted for seizure, and this area was right next to a major new research facility being built by the pharmaceutical giant, Pfizer.
Right. So the city of New London planned this massive redevelopment project. It was designed to support the Pfizer facility and, revitalize what was an economically struggling area. The plan included private offices, residences, a hotel, retail space.
All owned and operated by private developers.
All private. The city wanted to condemn Suzette Kilo's property and transfer it to the New London Development Corporation, which was a private, non-governmental entity.
And their legal argument was, as you said, revolutionary. And for property rights advocates, deeply disturbing.
Their claim was that public use should be interpreted broadly to mean public purpose or public benefit. So since the new development promised potential jobs, higher tax revenue, and overall economic revitalization, the city argued that this economic benefit was enough to justify forcing the transfer of private property from one set of owners to another set of private developers.
And this is the moment. This is where that 7th century instruction, property shall not be taken unjustly, it just collides head-on with modern fiscal policy.
The core ethical question was this. Is it just to take property from a less powerful citizen against their will, simply to enrich a larger, wealthier, and more politically connected private entity based only on a promise of future tax gains? And the outcome was, as you can imagine, intensely controversial. A narrow 5-4 decision in favor of the city of New London.
Wow.
The majority opinion basically adopted that public purpose definition. It said that the government's comprehensive economic development plan, even if private companies carried it out, served a legitimate public purpose and therefore qualified as a public use under the Fifth Amendment.
So this was a monumental shift. The precedent was set. Property could be taken under eminent domain and handed to a private developer, as long as the government could argue it was part of some beneficial economic plan.
It was, but the dissent was absolutely fierce. And it reflects the depth of this philosophical disagreement, which, as you said, directly echoes our ancient source material.
Tell me about the dissents.
They were extraordinary, both for their legal rigor and their ethical passion. They argued that the majority had essentially, eviscerated the protection of the Takings Clause. Justice O'Connor, who had previously been a pretty strong proponent of eminent domain in some cases, wrote one of the most blistering dissents.
What was her main point?
She warned explicitly that the ruling gave government, and I'm quoting here, license to transfer property from those with fewer resources to those with more.
That statement is incredibly important. She wasn't just arguing about legal terms. She was talking about power dynamics, about class.
Precisely. O'Connor saw this as a massive shift in power that would fundamentally erode the security of small property owners. Once you accept economic gain as public use, there's almost no limit to the government's taking power, because almost any piece of land, if you develop commercially, can promise more tax revenue than its current use. And that vulnerability, it disproportionately affects people with fewer resources, the less politically connected. It's the ancient problem all over again, the strong taking from the weak.
Exactly. And then Justice Thomas, in his dissent, he went straight back to the historical contract, to the original intent of the framers.
What was his argument?
He argued from an originalist perspective. He stated emphatically that the framers of the Fifth Amendment would never have allowed the government to take private property just to give it to another private party. The original idea was to address genuine public necessity, not just financial convenience.
So he was saying the majority had basically changed the Constitution. He said the majority opinion effectively deleted the word use and replaced it with purpose. And by doing that, they turned secure private property into a kind of tenant at will status, where your ownership depends on the state's ever-changing economic plans.
And the fallout from this decision was immense. The public reacted with alarm.
It wasn't just libertarians. It was a broad coalition of people across the political spectrum who saw this as a dangerous government overreach. The outcry was so loud and immediate that it translated directly into legislative action.
So the states pushed back.
Dozens of states, within just a few years of Kelo, passed new laws or constitutional amendments specifically to limit the use of eminent domain for purely economic development. The public, through their representatives, essentially said no to the Supreme Court's interpretation and demanded stricter protections be restored.
And this legislative backlash is the crucial connection point for our deep dive. This modern debate is a perfect mirror of the 7th century one. Can state action, in this case economic necessity, override the strict requirement of justice? And the U.S. public emphatically sided with the ancient principle. The Kelo dissenters, the state legislatures, they were all essentially arguing for the prophetic position, that property ownership must be secure against arbitrary action, especially when that action is just cloaked in the veneer of promised development, which, by the way, often doesn't even materialize.
I remember reading that the Pfizer development in New London actually fell through.
It did. The promised jobs and tax revenues never came. The land was left empty for years.
Right.
Vacant lot where Suzette Kelo's home used to be.
So the state decided that financial efficiency trumped the security of an individual's home, and in the end, they got neither. The ethical boundary was breached for nothing.
Okay, so now let's shift our focus again. We're going to examine Pakistan's constitutional framework, which, as it turns out, provides a fascinating counterpoint to the Kelo situation. It shows a system where the commitment to property protection is not only explicit, but often fiercely enforced by the courts.
That's absolutely right. It's a system where the Constitution seems to have learned lessons from both historical traditions and modern legal disputes, enshrining property protection at the highest level.
So it's not treated as some secondary issue.
Not at all. It's foundational. You see this in two key articles of the Constitution. First, you have Article 23. It establishes the fundamental right of every citizen to acquire, hold, and dispose of property.
And calling it a fundamental right is key.
It's everything. It places property rights on the same high plane as the right to life or freedom of speech. When a right is fundamental, it means any government action that infringes on it has to meet the highest judicial standard. It can't be overridden by, mere legislative convenience.
And then the government's power to acquire property is tightly controlled by a second article, Article 24.
Indeed. Article 24 explicitly prohibits arbitrary seizure and unlawful deprivation. It makes it crystal clear that if property is taken for a genuine public need, mandatory compensation must be paid. These two articles work together to force the state to prove overwhelming public need, stick to strict procedures, and pay justly.
So the text of the law is clear. But the real power, as always, is in how the courts interpret and apply it, especially against these huge development projects. How does that judicial reinforcement work in practice?
The judicial approach has been pretty uncompromising. The Supreme Court has repeatedly established strict, often interventionist limits on state power. It acts as a crucial check on the enthusiasm of the executive and legislative branches for, fast-track development.
So what does that look like?
Well, first, the court insists on that fundamental right status. This means the burden of proof is heavily on the state. The government can't just issue a notice saying, we need this land. They have to demonstrate that the necessity is overwhelming and the public purpose is genuine, clear, and immediate.
That's a much higher bar than the rational basis review that the Kelo majority used.
A much higher bar. Second, the court demands that any use of eminent domain has to be proportional. They scrutinize the government's plan to make sure the public good you get is proportionate to the loss the individual property owner suffers.
So they'd ask questions like, were there other less intrusive options?
Exactly. Were less intrusive alternatives considered? Was the taking confined only to the area that was absolutely necessary? And third, compensation isn't just mandatory. It has to be timely, adequate, and just. The courts actively monitor the valuation process to stop the state from lowballing owners or dragging out payments, which are common tactics to pressure people into giving up.
Let's get into some specific cases, because that really makes these abstract ideas tangible. The sources mention cases like Pakistan Railways v. Collector and Imran Khan versus LDA. What did those rulings establish?
Those cases were instrumental in cementing that due process is paramount. In disputes like Pakistan Railways v. Collector, the courts confirm that government bodies, even for major infrastructure projects, cannot just bypass the established legal procedures. If the government messes up the process, fails to notify properly, doesn't value the property correctly, denies a hearing, the whole acquisition can be thrown out.
So efficiency can't trump legality.
Never. But maybe the most telling example, the one that directly counters the whole kilo philosophy, is the Orange Line case. This was a massive, nationally important project, a new rapid transit system in the city of Lahore.
Right, a huge infrastructure project. Just the kind of thing where you'd expect the government to get its way.
You would. The project was deemed critical for public transport, yet it faced intense judicial scrutiny. The Supreme Court intervened specifically on the issue of acquiring land around the main line, particularly where it impacted historical sites and private homes, these so-called buffer zone takings.
And what did the court decide?
It didn't halt the project entirely, but it imposed very strict conditions and limitations. The ratio decidendi, the core legal reasoning, was rooted in proportionality and due process. The court ruled that while the Orange Line itself served a public purpose, the government had failed to establish the necessity for taking all the associated land around the heritage sites. So the court basically said, we accept the train is for the public good, but you can't just grab all the adjacent property because it would be economically convenient for future development or to make construction easier. That's precisely it. The judiciary was actively enforcing the principle that property cannot be grabbed in the name of development without due process. This ruling is a powerful testament to the fact that economic development, however important, doesn't give the state a blank check to violate the fundamental rights of its citizens.
It was a direct resistance to that kilo-style expansion, where a general promise of economic benefit is used as a cover for arbitrary property transfers.
Exactly. The court was policing that line very carefully.
So it really seems that this modern jurisprudence in Pakistan is deeply rooted in the same ethos we found in the 7th century Charter of Medina. The individual's right to their property comes first. The state's desire for efficiency or expansion comes second. The state has to prove its case. The citizen's property is the default sacred position.
That's a perfect summary of the principle in action.
So we've reached the culmination of this journey. We've tracked a core ethical principle across 1,400 years, 3 continents, 3 very different legal traditions. And the conclusion, when you look at the comparative analysis from our sources, is just stunning in its uniformity.
There really is a kind of universal legal DNA when it comes to property rights. It's a powerful testament to the idea that certain ethical principles are just, prerequisites for a just and stable civilization, no matter the era or geography.
Okay, so let's use that comparison to really structure this analysis. Let's start with the fundamental nature of property itself. In the Islamic era, as you said, property was declared sacred. In modern constitutional law, like in Pakistan, it's declared a fundamental right.
And the weight of those terms, though separated by centuries, is functionally identical. When something is sacred, it implies a divine and immutable protection. The government can't touch it without incurring both spiritual and immediate real-world liability.
And when it's a fundamental right,
it implies a constitutional, immutable protection. The government can't touch it without meeting the absolute highest judicial standard and due process. Both terms assert that the source of the right, whether it's divine law or constitutional law, is external to and superior to the temporary power of the state itself. Okay, next, let's compare the rules for acquisition. The 7th century rule was categorical: no state seizure without justice or consent. The modern rule, the one enforced in Pakistan and argued for by the Kilo dissenters, is that eminent domain is allowed only with proven necessity and just compensation. And necessity is a modern legal stand-in for justice in this context. It forces the state to prove not just that the property would be helpful or convenient, but that it is absolutely required for a clearly defined, legitimate public function.
And compensation is the mechanism for restitution.
Exactly. It ensures the individual isn't unjustly penalized for the public's need. So if the government can prove necessity and pays justly, that fulfills the modern definition of a just taking.
But this does raise a critical question. If necessity is the requirement, how does that ancient immediate decree return the land immediately? How does that scale to a modern centralized state with complex infrastructure needs? Isn't a prophet's decree fundamentally more arbitrary than a detailed judicial review system, even if the outcome in that one case was just?
That's a profound question about scalability. The difference is in the enforcement mechanism and the moral authority. The prophet's ruling was immediate and non-negotiable because his authority was based on a moral and spiritual mandate that transcended bureaucracy.
Okay.
In the modern state, judicial review serves that same function. It's the specialized, institutionalized check on arbitrary power. The goal is still state accountability, even if the mechanism has to shift.
So in Medina, officials were liable for wrongful taking, with severe consequences. Today, we rely on judicial review to limit government acquisition.
The citizen, through the court, still has a check against arbitrary power. The ultimate aim protecting the individual from the state is preserved. And finally, let's look at the definition of legitimate use. This is where the U.S. experience provides the biggest modern warning. The ancient warning was absolute. Whoever takes land unjustly will be punished. It sets an absolute moral threshold against gas, and that connects directly to the modern necessity that public use must be genuine, not a cover for private gain.
This connection seems to be the key ethical thread running through all 1400 years.
It is. That spiritual warning against taking unjustly in the 7th century is the perfect legal and moral defense against the Kilo scenario in the 21st. The moment public use becomes a pretext, a cover for transferring property from a regular citizen like Suzette Kilo to a more powerful private developer, it becomes an act of injustice. It becomes GASP, regardless of whether the state promises higher tax revenue.
So it sounds like the universal ethical lesson. From all three traditions, Medina, the U.S. descent, Pakistan's courts, it all boils down to the distinction between regulation and plunder. Absolutely. The core ratio decidendi, the underlying reason for all these laws, is universal. Property belongs to individuals, not governments. The state can regulate things, sure. It can enforce zoning, environmental standards, collect taxes, but it may not plunder. It may not arbitrarily seize assets just because some official thinks they have a better use for them. Justice, transparency, proportionality, those must govern every single act of acquisition. And why must every successful society, whether it's tribal or technological, arrive at this same conclusion? Why does the security of property matter so universally?
Because the security of property is fundamentally intertwined with human dignity, with liberty, and with civil stability. When your property rights are secure, you're an independent actor. You can invest your labor, you can plan for the future without fear.
And when they're not?
When property rights are insecure, when you fear that knock on the door might be the government or a politically favored developer coming to take your assets, the entire social contract dissolves. Liberty collapses because you become utterly dependent on the government's goodwill. Investment dies because the risk is unmanageable.
And corruption rises.
Corruption rises because powerful people use the pretense of public purpose to enrich themselves. And ultimately, tyranny grows because the primary check on absolute state power, the inviolability of the individual sphere, has been removed.
It really is the cornerstone of a free society. If you can't securely own what you work for, you aren't a free citizen. You're fundamentally dependent on the transient benevolence of whoever's in charge. This deep dive shows that whether you start from a sacred text in the 7th century or a constitutional amendment in the 18th, a healthy society has to aggressively secure the individual's assets against the state's greed or temporary convenience. The convergence is undeniable. Early Islamic law, American constitutionalism, and Pakistani jurisprudence all settle on this central truth. Property is dignity, and dignity must be protected by law, even from the lawgiver itself. What an extraordinary tracing of an ethical line through history. We started with the Prophet Muhammad establishing these profound ethical limits on state power in the sands of Arabia, making property something sacred, protected by spiritual decree. We then witnessed that high-stakes stress test in modern America, where the U.S. Supreme Court's narrow expansion of eminent domain in Kalo sparked a massive bipartisan public and legislative backlash. A backlash that powerfully reinforced the original, stricter intent of the Fifth Amendment's protections.
A real pushback from the people.
And finally, we saw Pakistani jurisprudence through Articles 23 and 24 and the forceful intervention of its Supreme Court, providing this robust model of constitutional safeguards. They ensure that due process, necessity, and proportionality remain the absolute minimum standards for any state acquisition.
Pushing back against that easy argument of economic expediency, exactly. The overarching lesson we can extract from all this is timeless and universal. A nation truly prospers, it achieves stability, and it guarantees liberty only when every citizen can sleep knowing that their home, their land, and their livelihood are protected. Not by the shifting whims of political power or financial influence, but by the unwavering, non-negotiable demands of justice. Well said.
The core measure of a civilization isn't how efficient its bureaucracy is, or how tall its development projects stand. It's how secure the foundation is for the humblest citizen's home. So we encourage you to reflect on your own society. How does your government truly balance state necessity versus individual dignity? Where does property stop being merely an asset and start being a sacred, absolute boundary? Thank you for joining us on the Deep Dive. We'll see you next time.